BLB Biz Law Benton News. My name is Morgan Stonebridge.
And I'm Julie DeSantis. Today we will be discussing employment discrimination and focus on Dukes et al. Versus Walmart case. To start, what is employment law? The relationship of employer and employee is created by the agreement of the parties and it's subject to contract principles. If the contract states a specific duration, the employer cannot terminate the contract at an earlier date unless just cause exists. The duties of an employee include performing the service of the contract, refraining from disclosing trade secrets, and allowing the employer to freely use any inventions created on work time with employer materials called shop right. The rights of an employee include to be paid according to the contract and at least the federal minimum wage.
As we have seen in many cases, there are many violations of the employment law which leads to employment discrimination. Employment discrimination law seeks to prevent discrimination based on race, sex, religion, national origin, physical disability, and age by employers. A growing body of law also seeks to prevent employment discrimination based on sexual orientation. Discriminatory practices include bias in hiring, promotion, job assignment, termination, compensation, retaliation, and various types of harassment. The main body of employment discrimination law consists of federal and state statutes. The United States Constitution and some state constitutions provide additional protection when the employer is a governmental body or the government has taken significant steps to foster the discriminatory practice of the employer.
There have been many anti-discriminatory laws implemented, such as Title VII of the Civil Rights Act of 1964, Equal Pay Act of 1963, Pregnancy Discrimination Act, Age Discrimination Employment Act, and Americans with Disabilities Act. Title VII of the Civil Rights Act of 1964, as amended, forbids discrimination on the basis of race, color, religion, sex, family circumstances, or national origin. An act to enforce the constitutional right to vote, to confer jurisdiction upon the district courts of the United States, to provide injunctive release against discrimination in public accommodations, to authorize the Attorney General to institute suits to protect constitutional rights in public facilities and public education, to extend the Commission on Civil Rights, to prevent discrimination in federally assisted programs, to establish a Commission on Equal Employment Opportunity, and for other purposes. The Equal Employment Opportunity Commission, or EEOC for short, administers the act. The EEOC issues a right to sue letter that enables the person claiming a Title VII violation to sue in federal court district.
This brings us to the well-known Dukes versus Walmart case. The issue before the Supreme Court was whether the female employees as a group could be certified as a single class. Evidence showed that female employees held 2/3 of the lowest level hourly jobs at Walmart, but only 1/3 of management jobs. Furthermore, women overall were paid on average $1.16 per hour less than men in the same jobs, even when women had more seniority and higher performance ratings. We will now go to Michaela Akins to further discuss the case.
Thank you, Morgan.
I'm here at the Walmart to further discuss the Dukes versus Walmart case. The June 2001 sex discrimination case filed by Dukes covered all female employees of Walmart retail stores in the United States.
Walmart was charged with discrimination against female employees in compensation, promotion, and job assignments in the violation of Title VII of the Civil Rights Act of 1964. The plaintiffs alleged that Walmart mistreated women in various ways. They earned much less than their male counterparts, even when they had more experience than men, or performed better than them. The case also alleged that Walmart prevented women employees from advancing by prohibiting them from working in departments that were traditionally assigned to men and often paid more, denying appropriate training to them, not posting all management openings to women, and underestimating women's abilities to apply for promotions. In the Dukes et al. Walmart case, Betty Dukes, a female low-level Walmart employee at Pittsburgh, California, with 5 other women, filed a class action against the alleged violation of civil rights by the company. The allegation was that the company's policies resulted in nationwide discrimination against women in their employment, as seen by the lower pay for women than men in the same type of job, and longer delays before women were promoted as compared to men employees. The classification was done by the U.S. District Court of the Northern District of California
which was satisfied that the plaintiffs fulfilled the statutory requirements of Rule 23A and 23B. The class had more than 1.5 million, all of whom were women employed by Walmart after December 26th of 1998. Walmart argued that the court should require individual lawsuits from Walmart employees as the size of the class made it impossible to manage and increased costs disproportionately. The United States Courts of Appeals, Ninth Circuit, upheld the class certification 3 times. It is safe to say the ruling was a complicated one. You've heard about firms that are too big to fail. Now the Supreme Court has declared that companies are too big to be sued for discrimination. The court threw out Dukes versus Walmart, the largest sex discrimination lawsuit in history, waged against the world's biggest company, essentially on the grounds that it dealt with too many women. In doing so, the court has made it much harder for employees to challenge bias that results from a broad corporate culture instead of the misdeeds of a few individuals. Ironically, the wide range of Walmart's alleged discrimination, coming from lots of managers in lots of places, became the reason the company was let off the hook. The Supreme Court ruled that absent a clear policy of discrimination, Walmart can't be held accountable for the cumulative decisions of its dispersed network of managers. I had the chance to speak with a local Burlington employee in the store today who wished to remain unidentified.
Yeah, I heard of the case when I came in and became an employee here at Walmart in Burlington. But I knew that things had changed after the case had happened, and it scared the corporation, and the employee and employer relationship has been a lot better than in the past. One of my bosses here is actually female as well, and I've gone up in position. I'm pretty happy working here at Walmart in Burlington.
As you heard from our fellow Walmart employee, Walmart has taken steps in the right direction to improve its discrimination policies and its corporate culture today. Now back to Morgan and Julia in the studio.
Thanks, Michaela. As you can see, this case has had a big impact on the industry and continues to come up today.
In the Walmart case, there are claims of disparate impact. Disparate impact states that employment practices that make no explicit reference to race, color, religion, sex, gender, or national origin, but have an adverse effect on the protected group. In this case, the employer must show that there is a job-related business necessity for the practice in question, and lack of intent is not a defense. On the other hand, there is disparate treatment, which exists where employer treats some individuals less favorably than others because of unpermitted factors such as their race, color, religion, sex, or national origin. In this case, proof of the employer's discriminatory motive is essential.
The female employees claimed that local managers exercised their discretion over pay and promotions disproportionately in favor of men, which has an unlawful, disparate impact on female employees, and that Walmart's refusal to cabin its managers' authority amounts to disparate treatment. Disparate impact means that it is not necessary to prove Walmart had clear intentions of discriminating against women in hiring, promotion, or pay. Instead, the plaintiffs can prove discrimination through statistical data.
Thank you for watching BLB, Biz Law Benson News. My name is Morgan Stonebridge.
And I'm Julie DeSantis.
Stay classy, Eli.